applied for her extradition on certain grounds. Everything has been done from the South African side, if I could call it that. The Americans are busy working on that application by the state or by the South African government, and they promised to expedite the issue. But as I have said previously before the Judge President, if Charlotta is extradited before the trial date, she will be accused number 17 and we will continue. If she, for some other reason, is not present in South Africa, by the time the trial starts, we will go on without. That was the undertaking that I gave, and it is still the same.
So the presence of accused number 17 is not a condition to the trial starting.
No. But I must say, if one listens to the undertakings by the US, she should be. But I can't guarantee as a plea.
Thank you. I want to establish next who is represented, who are representing the accused. Accused number 1, I have the name here of Mr. Piper. Is that correct?
My Lord, I confirm that I appear on behalf of accused number 1.
Thank you. Accused number 2, I have the name of Advocate Mazibuko.
My Lord, I appear on behalf of accused number 2, Advocate Mazibuko is the one for the state.
Your name again, please? Mogele.
Mogele. My Lord, whilst I'm still on my feet, I'd better like to confirm that I've received a request from Mr. Mancha, who's representing case number 6, to stand in for him, and also indicate to the court that he's also withdrawn as an attendant of record for case number 6.
So Mr. Mancha is no longer appearing for number 6. It is you yourself.
No, my Lord, I'm only standing in for him to confirm his withdrawal. I believe another representative will be taking over the meeting.
Thank you.
That's the context.
Mr. Houders, you are appearing for accused number 3.
Yes, my Lord.
Number 4.
My Lord, I'm appearing for accused 3 and 4.
And
my
13.
junior with me, my Lord, is Ms. Govender. For accused 3 and 4, we were instructed by BDK attorneys in Johannesburg. And there's an amendment that must be made even to the more recent indictment, my Lord. You'll see, with respect, my Lord, it says accused 4 represented by accused 2. It's just a typographical error. It's accused 3.
Yes.
And then, my Lord, the two of us, that's Ms. Govender and I, appear for accused number 13. But in that instance, my Lord, we're briefed by another firm of attorneys. It's Victor and Kwashu attorneys. And that's for accused number 13, my Lord. But I'll wait, if you're going through the list, my Lord, until then to put that on record.
Thank you, Mr. Houders.
Thank you, my Lord.
And then we get to accused number 5, that is Diamond Hill Trading. Mr. Jagan, I have the name here. Thank you, Mr. Jagan. And then accused number 7, I have here the name of Advocate Moholo.
May I just place myself on record, Your Worship? Mr. Mancha has withdrawn as the attendant of record, as indicated my colleague earlier. I am actually coming here for accused number 6, and my name is Rambao.
Your name again, please?
Rambao, R-A-N-B-A-U. The initials are W-T.
Thank you, Mr. Rambo. Accused number 7.
As the court pleases, my Lord. My Lord, I confirm my appearance on behalf of accused number 7, and may I just address court on with regard to accused number 8. He has since been, it's a company, then it has been liquidated,
yes.
My Lord, so it does not have any representative.
Yes.
As the court pleases.
Are you Mr. Moholo?
Yes, I am Mr. Moholo.
Thank you. I just wanted to confirm that.
As the court pleases.
Accused number 9, Mr. Piper. No.
As the court pleases, my Lord, I appear on behalf of both accused number 9 as well as accused number 10.
And your name again,
I am
please?
Machini Mutloung, my lord.
Motlaung.
Mutloung.
Thank you.
That's a court cases.
Accused number 11.
As it pleases the court, my lord, my name is William Morobane. I'm appearing on behalf of accused number 11, Mr. Zulu. I'm taking this matter on behalf of Mr. Maakane, who's in Johannesburg. He's still on brief.
Accused number 12. Mr.
As the-
Mazibuka.
As the court pleases, my lord, I
you.
confirm my appearance on behalf of accused number 12. My lord, it's Mr. Nigel Masala from Mato Attorneys, standing in for Mr. Mazibuko, who is briefed by Mato Attorneys in this instance, Your Worship. My lord.
And my lord, as I said earlier, for accused number 13, I'm with Ms. Governor, but instructed by Victim Kwashu attorneys.
Thank you, Mr. Otis. Accused number 14. I have here the name of Mr. Potgieter.
My lord, I appear on behalf of accused number 14. I did previously as well.
I understand.
As it
What is your name again?
on his paper.
Mr. Piper. Thank you, Mr. Piper. Accused number 15.
My lord, I also appear on behalf of accused number 15.
Are you also appearing for accused number 16?
No, my lord.
I have the name here of
My lord, I appear on behalf of accused number 16, Van Skalkwyk, initials CJ, on the instructions of Kramer Weyland.
Is there any appearance today for accused number 18?
My lord, I appear on behalf of accused number 18 on the instructions of Ulrich Roux attorneys from Johannesburg.
Thank you, gentlemen. Then, are we then in a position to formally postpone this pre-trial to the date of 20 January 2023?
Correct.
One of the accused number 13, I think Mr. Magashule is raising his hand. Mr. Otis?
May I approach him?
Yes, please.
Pardon me. Well, the accused number 13 is aggrieved by the postponement and would like to address the court if your lordship is prepared to hear him.
Yes, I think you must, I'm going to adjourn for a short while. And then, Mr. Otis, I think you must consult with your client and then you can address the court on his behalf.
As your lordship
Thank you.
please, I
The court will-
apologize for this morning.
The court will now adjourn until I'm called again.
is being added as an accused and the extradition is sought. He's unaware of any steps that have been taken in that regard, and he doesn't believe that they're playing open cards. She was previously a state witness. Your Lordship will see that from the previous indictment she was listed as witness number 42. He says she's now changed status to an accused person, which begs the question of whether they ever received any statements from her or not, to have included her as a state witness previously. He thus disputes that the state is ready and challenges them to charge him separately, and says if they really wanted to expedite matters, they could charge him separately, and he would be prepared to run his trial on his own, which would be quicker and would have respect for his political career and the prejudice that's been caused to him. He says over and above that, he doesn't believe that this indictment is in its final form because of the uncertainty about Ms. Chiloto, and believes that it will be amended. So he would ask, if possible, this court to bind the state to the finality of this indictment, because he doesn't believe that this is the case. He is of the view that this is a purely dilatory tactic that's been put together or orchestrated to prevent him from standing for his position within the ruling party. And he says on this new indictment, as your Lordship will notice, there's no list of witnesses attached to it. So he says that's further indicative of not being final. He thus wants all of these factors recorded. He apologizes to your Lordship. He asked me to express this. He didn't know the procedure. He's not used to court procedure, and believed that he was entitled to address your Lordship. I explained to him that when he has representation, he must give us an instruction, and he thus instructed me accordingly and requested me to place all of this on record on his behalf, my Lord.
Thank you, Mr. Herders. I just want to know from you, as far as Begane Sodi is concerned, accused number 3, is he attending to petition the SCA?
Yes, my Lord.
And accused number 4?
Yeah, 3 represents 4, my Lord, so they both are, as is accused number 13 as well. We are 3 of the 4 applicants for leave to appeal that were refused leave to appeal and intend to petition the Supreme Court of Appeal.
So it is accused 3, 4 and 13?
As well as, I believe it's accused number 1 as well, my Lord.
Accused number 1 as well?
Yes.
But he wasn't involved in the application?
No, I beg your pardon, my Lord.
It's 2, 3, 4 and 13.
We act for 3, 4 and 13, but there was, I've just got all the names confused, my Lord.
No, it's accused number 11.
As your Lordship, please.
Yes, can I just find out, appearing for accused number 11 is Mr. Morabane?
Indeed, so my Lord. The accused is in court.
Yes, but is the accused intending to petition the SCA?
It is our instructions to do so.
So, Mr. Denison, it seems to me that there is a request on the one hand that accused number 13 be charged on his own in a separate trial, but on the other hand, I'm informed by the representatives that accused 3, 4, 11 and 13 want to petition the SCA against the finding and the judgment of Naidu J in the application for leave to appeal. So, what is your attitude? Are you standing by the decision to have this pre-trial postponed to a certain date?
Yes, that was agreed on, arranged between the state and the relevant parties. And as I said previously, I think that is the correct manner to handle this process. To first have these collateral issues dealt with. But I wish to just place on record, I have no problem with these applications per se. because it is the right of the accused. But unfortunately, these applications delay the proceedings. That is unfortunately so. And it's not a question of my legal colleagues wasting the time of the court or anyone else. It is a question of it is the right of the accused. And accused number 13 must understand that. These things take time. Now, how you can blame the state for a delay in this matter, I don't know, because it doesn't make sense. It is indeed so that we oppose these applications by the defense, but that's not delaying the process. Furthermore, I've said it previously and I say again, me, my office and my head office do not do politics. There's no political interference. Nobody has phoned me or told me to do this, that, and the following in the light of a political situation in this country. We determine charges on facts, and that is how far it goes. Pertaining to the separation of trials, apparently that case number 13 wants, my lord, to do this case in that piecemeal manner will never suffice. It will be a miscarriage of justice. We'll lead the same evidence over and over and over. So no, the state will oppose such an application. The so-called amendment of the indictment, your lordship will see that I have already entered all the allegations and charges against accused 17. That will not change. The same with accused 18. We do not intend, and I give that undertaking, to arrest anybody else before this trial starts. We have all the accused, except for Charlotte, but she's already been written in to the indictment. We're just waiting for the Americans to extradite. And whether accused number 13 believes us or not, I can give you the undertaking. A huge amount of work has gone into that extradition application. It is not a secret. The Americans are extremely thorough in considering these type of applications for extradition, and that is why it takes time. Then the copy of the docket. All the accused have to understand that the investigation of a case of this nature is an ongoing process. It is not a question of the police or me or anybody else from the prosecution standing up one morning and deciding the investigation stops now. That doesn't happen because there's an obligation upon us. Any new information or evidence that comes to light has to be investigated. And the police are all the time following up on allegations that come to light or information that comes to light. And I say again, there's an obligation upon us to do such. And this will continue. And each time new evidence or new information is gathered, the defense will be informed. And they will be given the opportunity. I've got my admin personnel in court. The request is that that the defense bring hard drives to my office so that they don't have to pay for thousands of pages. Everything gets copied onto a hard drive and they can deal with it as they wish. And yes, it is so that the whole docket has been copied again, because I asked the police to do so, and they copied everything, the old, let's call it the old docket, as well as the additional stuff, the new information and evidence. And they did that for the purpose of, to ensure that they don't miss anything. That is the only reason why. So, in actual fact, there's no necessity to read everything again. Yes, I think I've addressed everything. Thank you.
Thank you, Mr. Denison. While you are on your feet, are all the accused in court?
Yes, they are.
Thank you. Are they all?
Except Shilota, of course.
Yes, that is accused number 17.
Correct.
And all the accused are on bail?
That is correct.
Is that including accused number 18?
That is correct.
Thank you. Mr. Ouders, I don't want to put you in a difficult position, but there is an agreement between the defense and the state that this pre-trial be postponed to the 20th of January 2023.
Yes, my lord.
Now, in view of accused 13, who is your client, in view of his agreement as far as that is concerned, shall I proceed and still postpone the pre-trial until that date?
Yes, my lord.
Thank you. Thank you.
My lord, sorry, before the matter gets postponed, I just like to address the court in relation to the request. My lord, I need to specifically make it clear that accused number 2 never agreed for the matter to be postponed to the 20th of January for pre-trial. And the reasons are very simple. One, the accused number 2 was provided with the contents of all the documents in this matter yesterday, which includes the amended indictment. What is so shocking about that, my lord, is that on the 7th of February this year, as the legal representative of accused number 2, I addressed a letter to the state's office requesting the process that we need to follow in order for them to provide us with a complete report. I only got information from Advocate Inez on the 10th of June, when the matter was postponed till today, that we needed to provide them with a hard drive. I undertook, which I even handed over it to the offices on the 10th of June. Again, I sent an email to Advocate Inez directly in August, in which I wanted him to confirm if the hard drive is ready for collection so that I can print the documents, take instructions, and also prepare. My lord, the sad reality of the matter is that on behalf of accused number 2, apparently there's a 212B response which was filed by the previous attorneys of the court. But in terms of the information and when I got appointed as a legal representative for accused number 2, I've never even seen if that 212B response is in line with the instructions which he has given me. So I've not even filed any 212B in terms of this matter. And even when we look at the procedures of court, my lord, Advocate Inesen and all the legal representatives in this matter, they know the 20th of January, even if we can consent to that date, it's not even enough. When you look at the processes at the Supreme Court of Appeal, currently they are on recess for 2 weeks. They're only going to come back on the second week of October. Again, they also have a role which has already been arranged in that court. The fourth term, again, they also have a role which has been arranged. Even if we can come back on the 20th, the pre-trial will never be ready. Even the accused, well within their rights that they want to petition, that matter can never be disposed of before the 20th. Again, we'll still be forced to come to court on the 20th of January for purposes of a pre-trial in this matter, for this matter again to be postponed to a later date, which will still have to be agreed to between the parties. Which places accused number 2 in a predicament. My lord, again, I've also been instructed to even place this on record. It's not even a matter that accused number 2 has intention of hiding it to the Honorable Court. Financially, he's been prejudiced. I have instructions to even bring an application for financial assistance against the very same department which has even placed him on suspension because they refused to cover for the legal fees, which again is a separate matter. Even if, my lord, that matter can be filed, if that financial application has not been finalized, it means accused number 2 would still have to come to court and request postponement for this trial not to proceed up until that financial application has then been disposed of, which again brings a delay in this matter. My lord, if the state can consider removing this matter on the road, there won't be prejudice in any event. They have all the personal particulars of all the cases in this matter. if they are still investigating any other point in this matter, surely they can still place it and provide that to the legal representatives of the accused persons, or in the event that they would decide to place the matter on. However, if the matter is not removed, all the accused, including accused number 2, they are definitely prejudiced. I don't know their financial capabilities, but surely, my lord, matters of this nature is very costly. Only for accused number 2, it has been a costly exercise. Because if you look from this time I got involved in this matter, on the 7th of February 2022, till to date, there's nothing which has been done by myself in this matter. Safe to say that I only appear in court and request and confirm the postponement. But in terms of putting putting motion into this car, I've never done anything. Maybe for the benefit of other legal representatives who have started with this matter, some things have been done. But as for case number 2, nothing has been done. Hence, my request, my lord, is that the state can simply remove this matter from the road for the betterment of everyone. Once they are ready, the matter can simply be placed on the road, so that the matter can then be possible. But the sad reality is that, my lord, on the 20th of January, the petition or in-application that some of the accused in this matter wants to file in the Appeal Court, that application would not have been set down. Even when you look even in terms of the rules of the Supreme Court of Appeal, my lord, in January, again, they're still on recess. That matter would still have not been placed on hold. It would still have not even been allocated to the presiding officers who would have to hear the said petition application. Now again, if then the matter is postponed to the 20th of January, what will then be coming to court for? To confirm the inevitable, because we're still going to confirm that the matter would have to be postponed, which you can even foresee, today, my lord. And again, my lord, I don't honestly want to overemphasize the issue of financial implications on behalf of accused number 2, but this matter on its own is very costly.
Yes, Mr. Mogale, but what is the position now? I'm told on the one hand that there is an agreement between the defense and the state that this pre-trial will be postponed to the 20th of January 2023. Now you are arguing to the contrary. Are you for a postponement to that date, or are you against it?
I'm against the postponement, my lord, as per my instructions.
That is your instruction?
Those are my instructions.
Yes.
And again, my lord, as I've already indicated, is that my instructions are in line with what I've submitted. And it's a well-known fact, my lord, and practice, that even if this matter can be postponed for a pre-trial, so as to see whether the Supreme Court of Appeal would have finalized or dealt with the petition application on behalf of some of the accused in this matter. The reality is that that application would not even have been allocated. There would still have not been a process that would still have to be complied with in the Supreme Court of Appeal, and that process would not even be completed even on the 20th or before the 20th of January. So if my client would concede to the postponement of this matter to the 20th of January, it defeats the whole purpose, because it means we'll still have to come to court and confirm what we can see today, that this matter will still be postponed further for a pre-trial.
Thank you,
Mr. My lord, my application is to request that matter to be removed from the roll. The state is not prejudiced. In fact, they even are afforded enough opportunity to put their house in order, my lord, so that at least when the matter is placed on the roll, then we can just simply move and arrange trial dates in this matter. As a court basis.
Thank you, Mr. Mogale. Mr. Denison, do you have any reply?
Very shortly, thank you, Your Lordship. Unfortunately for Mr. Mogale, there is an agreement between the state and at least 16 of the accused. So it is unfortunate, as I said, that there will be delays in cases such as these. Mr. Mogale now accepts that this process to the appeal court will not be finalized by the 20th of January. I don't know how you can say that. But the long and short, these matters have to be addressed. And no, the state is not going to remove the matter from the roll as it is.
Thank you, Mr. Denison. Am I correct if I say, and I've looked at the indictment, am I correct in saying that the criminal trial itself has no real chance of being disposed of within a month or two. It's going to be a long trial. Am I correct or am I wrong?
That is most definitely correct.
Could even take up to a year.
At least.
At least a year.
Yes.
Thank you. Thank you. In this matter, the counsel appearing for the accused and counsel appearing for the state have agreed that this pre-trial hearing is to be postponed to the 20th of January 2023. The reason being that some of the accused want to petition the Supreme Court of Appeal for leave to appeal against the judgment of Naidu J in an earlier application launched by them. The accused referred to in this respect is accused number 2, accused, I'm sorry, it's accused number 3, accused number 3, accused number 4, accused number 11, and accused number 13. Now, when the court was on the brink of postponing the matter to that date for the pre-trial hearing to be held, there was an objection by accused number 13 who expressed his dissatisfaction to the postponement of this proceeding. He says that the trial is politically motivated and by the postponement he is excluded from running for the top 6 as it was put by his counsel, Advocate Houders. He also complains about a new indictment, a new docket and so forth. Furthermore, accused number 2 by mouth of Mr. Magashule expressed also his dissatisfaction with the postponement because in the main he is financially prejudiced if he have to return to court on the 20th of January. Now, as for the objections raised by these specific 2 accused, the problem is that the main criminal trial in this matter will probably take a long time to finish. It will not be a month or 2. I'm informed by Mr. Denason appearing for the state that the trial will at least last and continue for a period of 12 months. So any financial prejudice at this point in time is not really affecting or should not really affect the financial position of any accused. As for accused number 13, it is so that he is one of the accused who wants to petition the Supreme Court of Appeal, and therefore he is in the same boat as the other accused who wants to appeal to the Supreme Court of Appeal, and that is an issue that has to be finished before the main trial can proceed. For these reasons, the pre-trial proceedings of today are postponed to the 20th of January 2023, and the accused are warned to appear in court again on that day, and their bail is extended for that purpose. Thank you, gentlemen. The court will now adjourn.